Did you wish to reserve any time for rebuttal?
Yes, Your Honor. I would like to reserve 5 minutes for rebuttal.
Okay. I will attempt to successfully inform you that when we arrive at moment 15, 15-minute mark. Okay, with that, we have Mr. Carlson on board too. We may proceed.
Good morning, Your Honors and Counsel. May it please the court. My name is Robin Keener and I represent the appellant, Ronnie Aaron Rondell. Mr. Rondell filed the instant lawsuit arising out of a motor vehicle accident back in November of 2016. The issue in this case is whether Daniel Romano is vicariously liable for the accident. Just to briefly go over some of the facts and relationships.
Before you do that, as you get ready to argue, I would point out, because it was brought to my attention, that a member of this panel has authored the opinion of Lambert versus Emerson that may touch upon this. So you may wish to speak to that case during your presentation.
Thank you, Your Honor. So to briefly go over the facts of the case, which are pretty straightforward, and the relationships of the parties. Tai Chi Deep is the registered owner of the vehicle operated by, Tai Chi Deep was the driver of the vehicle that collided with the motorcycle operated by the appellant, Mr. Rondell. And Tai's father, Quang V. Deep, is the registered title owner of the vehicle, which is a Honda Accord. Tai's girlfriend is Gabriella Ritchie, and Gabriella Ritchie is Daniel Romano's daughter. Tai and Gabby were in the vehicle together at the time of the accident. The issue in this appeal, as I indicated earlier, is whether Mr. Romano, who was in the process of purchasing the vehicle from Tai for his daughter Gabby's use, can be held vicariously liable. The trial court held that because Mr. Romano did not have legal title to the vehicle, he could not be subject to vicarious liability. And it is Mr. Rondell's position that he had a beneficial ownership interest in the vehicle, which would subject him to vicarious liability, or at least create a package.
Did Mr. Romano dispute the potentiality of vicarious liability, or as the did the legal title owner, sorry, I lose track of the names unless I write them down. Did the legal title owner dispute the possibility of vicarious liability by virtue of being the legal title owner?
At this time, the legal title owner has not disputed vicarious liability for the accident.
Okay. So you got one on the hook. You're trying to get a second one on the hook. Is that correct?
Yes, we think that there is the potential for both a beneficial owner and a legal title owner, subjecting them both to vicarious liability. And I think this goes to the heart of the issue. The concern in this case is we have Mr. Romano, who actually procured insurance for the vehicle a week before the accident. So he purchased a policy with Geico, insuring the vehicle as part of his intent to purchase this vehicle for his daughter. On the very same day that Mr. Romano purchased the insurance, Tai canceled his insurance with Geico. So we have an overt act by the parties evidencing the intent to sell the vehicle by Tai, as well as the intent to purchase the vehicle by Mr. Romano. We have Geico insuring this vehicle for the entire time period, albeit under different policies. And the elephant in the room is what's going to happen if Mr. Romano is absolved of liability for this accident. Because if Geico gets out of coverage for liability for Mr. Romano, as far as we understand it, it has now issued a reservation of rights letter to the driver of the vehicle, Tai, and to the registered title owner, Quang, saying that there may not be coverage for this accident. So it presents an interesting situation where we have a vehicle that's been insured, but because of the arguments of the policy, there's an attempt to get out of any coverage for the accident. So
Counsel, how does your position square with that passage in Arbach versus Galena, where I think it's the Supreme Court says that the concept of beneficial ownership in Florida law has not been an expansive one that extends to hold vicariously liable anyone with a theoretical right to control a motor vehicle. You know, at this point, it seems what we have before us is a theoretical right that he was in the process of acquiring ownership of the car, but had not yet arrived at that destination. I'm concerned how this concept applies to that passage, and if it does.
Yes, well, as an initial matter, I think the Arbach case is distinguishable because it was based on the family dynamics and the parent-child relationship, and the court expressing that it did not want to hold one parent vicariously liable for an accident when it wasn't a title owner, just by the mere fact that it was a parent and had some ability to exercise dominion and control over the daughter's actions, but you had another parent who was the legal title owner. And the Arbach court specifically noted that this wasn't to say that vicarious liability is limited to someone who is a legal title owner, that as long as someone had some sort of interest in a vehicle, that they could be considered a beneficial owner. In this case, the interest, this case, I think, is more akin to those situations where legal title hasn't transferred, but there was a sale of the vehicle. And in this case, the sale just hadn't been consummated.
Does this record demonstrate that there was an exchange of consideration for the acquisition of the vehicle?
There wasn't a purchase price for the vehicle, but there have been other
So
cases.
there's no purchase price and there's no consideration.
Well, I would say that there is consideration by the fact that Mr. Romano purchased insurance on the vehicle, paid the premiums on the vehicle, and was paying the premiums on the vehicle.
Well, I'm not sure that is expectation as much as consideration as much might be an expectation of future conduct. Is that enough to make someone vicariously liable for an accident that takes place before any act of ownership or even the authority to grant a bailment takes place?
I think that it's just the timing of it, right? It happened while it was occurring. So not only did he purchase insurance on the vehicle, he subsequent to the accident, and beneficial ownership is considered based on the overt acts at the time of the agreement and thereafter. So in addition to purchasing insurance on the vehicle, he also then stored the vehicle at his house for 7 to 8 months. And then he is the one that sold the vehicle. And there is a factual dispute as to who received the proceeds of that sale. Mr. Romano says that Ty received the proceeds of the sale, the driver of the vehicle, but Ty says he did not receive the proceeds of the sale. So there's a factual issue there. There's also a factual issue with respect to whether the vehicle had actually, or the title had actually been signed over to Mr. Romano, because Kwong, who is the registered title owner of the vehicle, can't remember whether he signed the title over. So it is true that it wasn't submitted to the state of Florida, but that happens in many cases, and that is not the litmus test for determining whether someone has a beneficial ownership. And in fact, in this case, after the vehicle was sold for scrap metal by Mr. Romano, the title was not changed to reflect the cancellation of title in Mr. Kwong's name for 1.5 years later. So it's the multitude of facts and acts by the parties that make this a factual question for the jury to determine, was there enough to show that Mr. Romano had a beneficial ownership in this vehicle? And, you know, there have been cases that say the mere fact that someone has procured insurance is enough to sustain a finding that there is a beneficial ownership interest in a vehicle. And, you know, one of those cases was, we've cited in our brief, and it is true that so the fact of that case, it's Quiroz. And if you want the full site.
Ms. Keener, I'd actually, I mean, Judge Casanueva asked you a question at the outset about one of our somewhat recent opinions, and I'd like to hear your thoughts on it. Do you think Lambert v. Emerson just has no applicability to this case?
I think Lambert v. Anderson was also a family relationship. And so.
Well, it was, but I mean, doesn't that, I mean, doesn't it make it all the more apt when, I mean, when the whole gist of the opinion is we're not going to expand vicarious liability to include beneficial owners when you've got the legal title owner on the hook. We're not going to expand it beyond that in a familial setting. Wouldn't that be all the more apt when you're getting outside the family setting? I mean, if anything, I would think it would be the opposite.
I think that just because Mr. Kwong hasn't argued that he is not vicariously liable doesn't preclude him from trying to make that argument after this all plays out. So we have a situation where, that's
an issue of law though, right? Who is or is not vicariously liable? I mean, you get a set of we have the facts that we have, but whether or not the vicarious liability can be extended beyond the legal title owner, that's an issue of law.
Well, I think that in most of the cases, albeit Lambert and Auberk were not, but most of the cases address whether you can escape vicarious liability based on the fact that you're just the naked title holder. And
but we don't have that here.
Right. No, we don't have that here.
So those cases really don't touch upon this because the legal title owner is saying, here I am, I'm the legal title owner. You're trying to expand it to someone else. In Emerson, when you said, I'm reading it, we do not believe there is a sound basis in the law to hold both the acknowledged title owner and a family member bailee liable for the bailey's entrustment of a car under the dangerous instrumentality doctrine. Why would that not apply outside the family context? Give me a rationale for your argument that, well, that's just confined to family members. Well, why should it be when the whole point of it was that Auerbach, as we construed it, is not an expansive case. It says vicarious liability for dangerous instrumentality doctrine should be construed narrowly.
I think because in this case, we have someone who has taken steps to purchase the vehicle, has procured insurance on a vehicle. The other party has demonstrated his intent to sell the vehicle, and the case is recognized that is an intent, by the legal title owner to divest themselves of the title to the vehicle. And so we have different factual situation, which should at a minimum let a jury decide, do you have an equitable ownership interest in this vehicle, subjecting you to vicarious liability? I think it is true that Lambert didn't hold the second parent liable, but there is a concern of inconsistent rulings in this case, and if something, and just the arguments that could be made in the future, because we don't have necessarily someone on the hook. Yes, it's our position that both can be liable, and there's nothing in the case law to say that just because someone is the legal title holder that there cannot also be a beneficial owner.
That was literally what Lambert v. Emerson said. Literally, I mean, in the exact words, you can't hold them both liable. Now that may be incorrect. That's up before the Florida Supreme Court. We might be wrong on that, but as of today, October 5th, 2021, that seems to be the law in this district.
I again would just reiterate that they can't. So if the law is that they can't both be held liable, what happens in this case if the jury determines that Kwong is not vicariously liable because he didn't have legal title holder or legal title, just because he's subject to the bare naked title exception, or the judge determines that if it is a judicial question, because just because that hasn't occurred yet doesn't prevent it from happening. And so perhaps then the summary judgment is premature.
Let me ask you, Mr. Kino, I thought that there was no dispute whatsoever that Mr., and I call him Kwong V, that he's the one that indicated all along, it's my car, I own it, no dispute whatsoever. And I'm trying to understand, so by virtue of him saying, it's mine, it's this, he's never denied that. Do you think that a court, or do you think later on he could disassociate himself with saying, oops, I did not mean that? I'm just trying to understand where would it be an issue for you?
Well, I don't think he can say that he wasn't the legal title owner, but I don't think there is, he could certainly argue that, yes, I was the legal title owner, but I fall within one of the exceptions to the rule for extending vicarious liability to the legal title owner. And obviously, we would argue against that and take the position that because of the facts of this situation where you're in process, and so it's just a sale that hasn't been consummated, that they can both be held legally liable. And understandably, your honors have ruled otherwise in Lambert, but we think these facts are different because of the overt acts taken and because of the fact that we have someone, there's no dispute that there was an intent to sell the vehicle. And the question is that enough to create beneficial ownership in Mr. Romano? And we think that's for the jury to determine because of just the timing of it all. And it leaves the potential of no remedy for the injured plaintiff when there's been insurance on this vehicle the entire time. But because
sorry to interrupt you, but you're at 15. I want to let you know something.
Okay.
Conclude
right.
and serve to save your time.
Yes. We just think it should be up to the jury to determine beneficial ownership. We think there's facts in addition to the insurance, the fact that he stored the vehicle after the accident, the fact that Mr. Romano is the one who sold the vehicle, and the fact that there are questions as to whether the title was signed over. There's questions as to who received the proceeds. And I will conclude by just, requesting that the court overturn the summary judgment ruling and save the rest of my time for rebuttal, please.
Give me a moment to stop the clock. Okay, counsel, Mr. Carlson, you may begin.
May it please the court. My name is Brant Carlson. I represent the appellee, Daniel Romano, the defendant below. This morning, we are respectfully requesting that this court affirm the decision on appeal and the entry of final summary judgment in favor of the appellee, Romano, and against appellant Rondell, who is the plaintiff below.
Mr. Carlson, and if I may, Mr. Carlson, let me ask a question that Ms. Keener brought out. The fact that I know this was on a summary judgment, and she raises the issue that, well, this case is not as clear cut as someone who says, I am the owner of the car, this is my car, I have the title. When you're dealing with somehow one person who's the title owner, basically stopped carrying insurance with the intent that he's not going to have the car anymore. And by dropping the insurance, an inference can be made that I do not intend on owning this car. Then you have another party who basically has insurance on the vehicle, which shows the intent, at least an inference, that he has the intent to purchase or to be the legal, title holder of the car. And because this is a unique case in terms of the transition, and with the overlay of Judge Lucas's opinion, which I thought he did a fantastic job outlining the history of where we were and how we are right now, by limiting that, we're narrowly limiting the beneficial owner. Why wouldn't this case be because of the posture summary judgment? There's enough of those issues that it ought to go to the jury. Your thoughts on that, please.
Yes, Your Honor. That leaps ahead a little bit into my argument and into the Christensen versus Bowen case, a case where the Florida Supreme Court overtly held, and I will quote, in these cases, any subjective intent of the title holder with regard to placement of his or her name on the title is not relevant to the beneficial ownership analysis. The Florida Supreme Court goes on to describe how evidence relating to subjective intent of parties, and in this case, we will argue that the sale is just that evidence of subjective intent is absolutely irrelevant to these dangerous instrumentality analyses, precisely because it becomes so messy and invites an ownership dispute into just about every case that involves a motor vehicle. And I do anticipate expounding on that point much further, but just my succinct answer is that with the evidence of subjective intent being raised, it is immaterial for purposes of summary judgment and does not rise to that level of raising a material dispute of relevant fact to foreclose summary judgment.
But wouldn't like subjective intent, I intend to do this, but here we have facts. We have facts to indicate that insurance was procured. we have facts that indicated that the Mr. Kwong no longer carried insurance on that specific vehicle. So it's not a matter of subjective, what I'm intending to do, what I have in mind, but actual facts in the record that indicate that. Would that be enough on a summary judgment posture to let it proceed?
Respectfully, Your Honor, no, and especially on the factual record that was before the lower court on summary judgment in this case. This takes me into my first point, which is just about the summary judgment evidence of record proper before the lower court. The summary judgment evidence firmly establishes that the appellee Romano had no legal right and no legal title to this vehicle and could therefore not be held vicariously liable for its use under Florida law. Each party defendant in this case, including Romano, Kwong, and Tai, have provided unanimous and consistent discovery responses which deny that Romano held any ownership interest whatsoever in the 2002 Honda Civic. Kwong and Tai particularly admit in their answer and affirmative defenses that Kwong is the owner of the subject vehicle. If that were not enough, Kwong v. Diep has testified under oath that he purchased the 2002 Honda Civic originally, and he further specifically admitted that he was the legal title holder and owner of the same vehicle on the date of the November 22nd, 2016 accident. These types of rock solid facts take this case out of the bare legal title holder arguments which the plaintiff is raising and into the realm of summary judgment. Tai v. Diep, who is the driver of the vehicle and Kwong's son, has also consistently identified in deposition testimony his father Kwong as the owner of the vehicle. Tai has also denied on the record that the vehicle was ever sold to Romano either before or after the subject accident. And I would argue that this fact specifically, Your Honor, helps to distinguish these arguments about the insurance being canceled or procured as to the vehicle, because there actually is no genuine dispute of material fact as to the sale of this vehicle. Kwong has said that he is the owner. Tai has said there was no sale. And the appellee, Daniel Romano, has said there was no sale and that he is not the owner. So you have an almost unusual. Yes, Your Honor.
Is that consistent? You mentioned Christensen versus Bowen. There was a passage there that I was going to ask you about since you brought up the case. I appreciate around page 503, where it says, vicarious liability arises from an identifiable property interest. And there is no contract here for sale. There is no ownership. Can an expectation of future transfer be an identifiable property interest to arguably impose liability? I'm concerned about how far this doctrine goes.
I understand your question, Your Honor, and my answer would be no. These types of inchoate interests, expectations, things which are unquestionably contingent on the happening of future events, these do not support vicarious liability in the state of Florida. The Auerbach decision by the Florida Supreme Court is explicit in its holding as to the property interests that are required to support vicarious liability. And it is in essence, legal title, bailment, lease, rental, some true identifiable property interest going well beyond a mere expectation that I might like to purchase it one day. And then just as to the almost unusual consistency in the deposition testimony and discovery responses in this case, if that were not enough, the record on appeal contains the full title history for the 2002 Honda itself. The complete certified chain of title for this vehicle shows that Kwong purchased the vehicle as he testified, and that Kwong was the owner of the vehicle on the date of the accident as he testified. So based on this, and it's important to start here from a factual standpoint, there is basically cumulative evidence that Romano held no legal right or title in this vehicle, and there is no dispute from the title holder, Kwong, that he is the true owner. That's what takes this case away from much of the appellant's arguments and distinguishes it from those cases where a legal title holder such as Kwong is trying to assert that he only has a bare legal title and that the beneficial ownership interest in the vehicle instead rests with somebody else. Here, Kwong is not making that effort, and that's what's so unique about the appellant's arguments. They are attempting to create additional equitable ownership in this vehicle, notwithstanding the fact that Kwong, the owner of the vehicle, doesn't contest his ownership, and that would be a drastic expansion in tort law in Florida. And so our point on this appeal, one of our main ones, is on this factual record, the appellant cannot reverse engineer the doctrine of a beneficial ownership exception or the bare legal title exception to create additional liability in non-parties that are not on the chain of title and don't have that identifiable property interest, that legal title or equivalent under Auerbach and Christensen. And I'd like to move on to the appellant's points specifically. There is no summary judgment evidence of record which actually creates a material dispute of fact here. To the contrary, the evidence just mentioned is unanimous and even cumulative of the fact that the appellee Romano is not vicariously liable for the accident and that no contract for the sale of this vehicle ever formed. As the parties have testified, there was no sale price. There was no exchange of consideration. Legally speaking, the vehicle was in every sense Kwong v. Diep's vehicle, and he does not dispute that. On evidence of subjective intent, I want to point out that most of the appellant's arguments on this appeal relate to Romano's subjective intent to purchase the vehicle, notwithstanding the undisputed fact that the sale just didn't occur. His subjective intent and actions in furtherance of that intent, such as purchasing insurance, are just not relevant to the court's analysis here under the Christensen case, a 2014 Florida Supreme Court case. And I'd like to quote at length from the Christensen court, which states in relevant part, furthermore, the irrelevance of subjective intent is consistent with Florida's statutory scheme, and that vehicle ownership is determined through legal title. Title 23 of the Florida statutes, which governs motor vehicles, defines owner in several chapters, and in all but one chapter, the owner is defined as the title holder. The court goes on to state, the legislature has developed a system whereby the rights and responsibilities of owners of motor vehicles are both assigned and dependent upon the existence of legal title. In reaching this conclusion, we note that title is a clear and simple method of determining ownership. And perhaps prophetically, the Florida Supreme Court says, if title ownership were subject to attack based on subjective intent of a title holder, then all types of cases that involve motor vehicles would become subject to litigation on ownership issues. And perhaps my favorite quote, and I will come back to this repeatedly, the better and more efficient and consistent rule is that title determines ownership, and ownership can only be disproven by objective evidence of a conditional sale or incomplete faulty transfer. So this standard of law borne out by the Florida Supreme Court basically ends the controversy on this appeal. The Florida Supreme Court has explicitly rejected the appellant's arguments and held that the better rule is that title determines ownership unless or until that owner can, and I quote, disprove by objective evidence or conditional sale or incomplete faulty transfer. So we have to point out that the appellant's entire case is flawed here because they seek to hold Kwong accountable simultaneously as the owner when Kwong himself is not attempting to disprove his ownership under that clause in Christensen. And instead, the appellant is attempting to use evidence and argue that the appellee, a non-title holder, somehow has an equitable interest or additional beneficial use in the vehicle sufficient to create liability out of thin air. This argument, in effect, turns the applicable standard on its head in a tail that wags the dog type of manner. And we would point out that about all of the case law relied on by the appellant, including the J.R. Brooks versus Kuraz case, is basically distinguished by this rule in Christensen. In Kuraz, that case involved an attempt by J.R. Brooks to escape liability, notwithstanding its purchase and maintenance of a vehicle. It essentially argued that it had vested title or somehow transferred the vehicle to one of its employees, Neil, and the court conducted a simple analysis. It said, well, was there a valid transfer to Neil? Was there a sale? Was there a gift? They went through the elements, they found none, and they held J.R. Brooks liable given its admission that it was the original purchaser of the vehicle. That, in essence, is the application of the rule just given in the Christensen court, and it complies with our argument. However, what Kuraz does not stand for is that You can simply find a person who benefits from a vehicle or can have some kind of insurance over the vehicle, or just a person without a legal title to the vehicle, and extend liability to them and have that liability run concurrent with liability of the actual title holder. That is simply in violation of the Christensen court's holding. The arguments of the appellant also somewhat misstate the beneficial ownership concept. Beneficial ownership as a concept is used by title holders to escape liability under these tests as we've described. And in Christensen, the Florida Supreme Court actually gives us a definition of beneficial ownership. It states, we conclude that beneficial ownership is unrelated to physical access to a vehicle, past use of a vehicle, or intent to use or not use a vehicle. Rather, beneficial ownership arises from legal rights that allow an individual to exert some dominion and control over the use of the vehicle. Thus, because a title holder has legal rights in the vehicle and is in a position to exert dominion and control over the vehicle, he or she is a beneficial owner. Then the court says the injection of theories of subjective intent would destabilize the law with regard to motor vehicles in the state of Florida. So what the Florida Supreme Court is doing is it's establishing a standard for what exactly beneficial ownership is. And it flows from legal right, from title, from lease or bailment. And it does not flow from ideas like where the vehicle is stored or who uses the vehicle, past use of the vehicle. And it even specifically says intent to use or not use the vehicle does not fall under that category. So the Christensen court outlining its definition of beneficial ownership distinguishes all of the appellant's arguments in this case, because as this court has noted, the appellant is relying on testimony as to subjective intent, intent to purchase the vehicle, including where the vehicle was stored following the accident, physical proximity to the vehicle, things of that nature. The Christensen court explicitly cites those types of arguments and says, not only are they not relevant to the concept of beneficial ownership, a court considering or incorporating those types of concepts in a vicarious liability analysis would run the risk of destabilizing Florida law on the topic. So for these reasons, and under the Christensen case, the appellant's arguments do not raise a dispute of material fact for purposes of foreclosing summary judgment. So they can certainly try and dispute little facts here and there. And I'm not saying there aren't factual disputes in this record, but the problem is under prevailing case law, those facts are not relevant or material for purposes of summary judgment. And this is why the lower court got the ruling in favor of defendant Romano correct. And third and finally, I do want to highlight that the appellant's arguments in this case are a typical example of the fuzzy standard that the Florida Supreme Court has repeatedly cautioned against in its efforts to appropriately limit the concept of vicarious liability for motor vehicle accidents. Stated differently, this case does involve the appellant's attempt to impute vicarious liability to a defendant with no title or other legally recognizable interest in the vehicle, which has been established, when the actual title holder to the vehicle does not dispute their ownership. And that would truly be like a first of its kind type of case. And on this point, I will turn to Auerbach versus Galena in closing. Auerbach is often cited a Florida Supreme Court case that dates back to 2000. It's often cited for the principle that the Florida Supreme Court requires that the person held vicariously liable have an identifiable property interest in the vehicle, such as ownership, bailment, rental, or lease. It's a quote that we've used quite a bit. And this case is an analogy to this case is sort of apt here because Auerbach involves a plaintiff suing a driver and then the driver's parents, the mother and the father. And as this court is well aware, the mother was a title holder of the vehicle and was properly held vicariously liable, but the father in the same household, parent of the driver, was not a legal title holder. And this case echoes through this court's decision in Lambert as well. In Auerbach, the plaintiff argued, much like the appellant here, that the father should be held liable. He's not on the title, but he should be held liable because he benefits. The facts in Auerbach were interesting because they argued that the vehicle itself was purchased with joint funds that were held by both the father and mother, so that the father should be held liable. They argued that the father test drove the vehicle and had control over its purchase, that the father's joint funds paid for the maintenance of the vehicle, that the father's joint funds paid for insurance for the vehicle, that the vehicle was kept in the father's driveway at his house, and that the father, who was obviously in charge of his children, could exert some kind of control over the vehicle that his own daughter drove. And if we analogize to Auerbach, it becomes clear that the plaintiff's case in Auerbach as to the father was quite a bit stronger than the appellant's case as to the appellee Romano here, with these additional facts, with the familial relationship, and with the father being so proximate to the vehicle and being able to control the effective use of the vehicle through his control as a parent over his daughter. But on these facts, the fourth DCA said, to analyze these types of dynamics to determine all the beneficial owners of a car is to impose a fuzzy legal standard that will encourage litigation and potentially expand liability beyond that which is justified. The Florida Supreme Court quoted that language, echoed it, and then raised the same exact concerns which were cited during the appellant's oral argument just a few minutes ago. The court ended up phrasing the question as whether or not the dangerous instrumentality doctrine could extend to hold a parent vicariously liable on those facts, even though the parent did not hold legal title to the vehicle. And the court in Auerbach said absolutely not. The court did not extend liability in that context. So in a closing statement, the court does say that contrary to the petitioner's position, the concept of beneficial ownership in Florida law has not been an expansive one that extends to hold vicariously liable anyone with a theoretical right to control a motor vehicle. Rather, the concept of beneficial ownership has been narrowly used in cases where the legal title owner is attempting to deny liability, such as the defendants in Palmer, Metzel, and Marshall. And of course, Your Honors, and I'll close on this, Quang V. Diep, as the owner in this case, is not contesting his ownership. And that distinguishes the appellant's arguments, their arguments on appeal, mainly under Christensen, mainly under Auerbach, and then it basically comports with all of the arguments that this court has previously set forth in the Lambert case. So in this context, Daniel Romano, the appellee, is respectfully requesting that the court affirm the final judgment and summary judgment granted in his favor under prevailing Florida law. Thank you.
Thank you. Counsel, I let him, opposing counsel, go a little bit longer, so you will have your full 5 minutes.
Thank you, Your Honor.
You may proceed.
Thank you. May it please the court. I want to direct the court's attention to both Lambert and Auerbach, which were decided after jury verdicts. So these were cases that were in a procedurally different posture, and it wasn't on summary judgment when all the facts had been adduced, but that the decisions were made. I would also note to go back to the question regarding why Lambert does not control. Lambert involved a bailment situation where the vehicle was being, the question was whether the wife, as the bailee of the vehicle, could be held vicariously liable when the husband, as the legal title owner, already was vicariously liable. We have different facts in this situation. In this situation, we have a vehicle that was being purchased by Mr. Romano. He was taking ownership of the vehicle, and there was going to be a transfer of ownership of the vehicle. It was not a bailment situation. I also wanted to address the reference to subjective acts in Christensen as determining whether or not there can be a beneficial ownership. In this case, we're not relying on subjective facts. We're relying on objective overt acts taken by the parties, which evidence the intent to transfer the ownership of the vehicle. And we believe it's for the jury to determine if those objective acts result in a beneficial ownership of the vehicle. And I would also note that those cases that have held that there is the mere fact of procurement of insurance is evidence of beneficial ownership of the vehicle means that at a minimum, it's a jury question for the jury to determine whether or not the party is a beneficial owner of the vehicle. So importantly, in this case, we haven't gotten to the jury. We haven't let the jury determine whether the fact that everybody intended for the vehicle to be sold to Mr. Romano, everybody recognized that the insurance was canceled by Ty and procured by Mr. Romano. The fact that Mr. Romano then kept the vehicle at his home and was the party who subsequently sold the vehicle after the accident creates a beneficial ownership in Mr. Romano. So I think that this case is distinguishable from the Arbach and the Lambert cases on the grounds that just the procedural posture alone, in addition to the lack of a family relationship and the fact that this involved an actual sale of a vehicle as opposed and a transfer of ownership as opposed to a bailment of a vehicle and a theoretical right to control the vehicle simply because you're the parent of the driver. The other thing I would note is that in Christensen, Christensen was dealing with, again, the exception to the bare legal title, the ruling that someone with a title is automatically liable unless they can show that they are just the bare title holder and they have no beneficial interest in the vehicle. So that case is directed to an exception to holding the title owner liable and therefore is not applicable in this case, where it's our argument that it is the facts and the intent to purchase the vehicle and those actions consistent with that intent that create the beneficial ownership in the vehicle. As I was saying, and I think I might have cut myself off earlier, the Quiroz court, it is true that they discussed whether there was a sale or a gift of the vehicle, but they specifically also held, in addition, there is significant affirmative evidence which independently supports the determination that the appellant retained ownership at the critical time, the time of the accident. Thus, there was testimony that the corporation paid in Florida for insurance on the vehicle and that it extensively dealt with the truck, perhaps even receiving the proceeds of the collision coverage after the accident. And in this case, we don't know who received the proceeds of the vehicle. In all these circumstances, the Quiroz court continued, the issue of the appellant's beneficial ownership and its right to control the use of the truck was at best a question for the jury. So I think this case falls in line with those cases that have recognized that the procurement of insurance and other factors that suggest a sale of the vehicle are at a minimum factual issues for the court or for the jury to determine whether or not the Mr. Romano had a beneficial ownership interest in the vehicle, which would subject him to vicarious liability. If the court does not have any further questions, I would just conclude by requesting that the summary judgment be overturned and it be left to a jury to determine Mr. Romano's beneficial ownership in the vehicle.
Thank you, counsel. Thank you both. Interesting case, and we would wish all of you good health, and we'll let you exit, as they say, at this point in time.
Thank you, Your Honors.
Thank you.
Thank you, Your Honors.